Okay.
Versus Jason Robinson, 19 CS 4856.
Good morning, everyone. Daquan Robinson appears in person in custody from CJF with Travis Schwantes from the Public Defender's Office.
All right, good morning, everyone. This matter is being live streamed at the request of the state. I understand that there's a party that is asking to be able to view the hearing. Is that correct, Counselor?
That's correct.
That's a member of the victim's family, I would assume?
There may be a member of the victim's family also that expressed requests from one of the enforcement officers.
All right. All right, and I need you to speak up and use that microphone. All right, the matter is being live streamed. So we're here on, I think, two issues. We're dealing with the rescinding of privileges for Mr. Robinson and I believe his motion to modify bail. Am I correct, everybody?
Yes.
All right, so in regard to the motion to rescind privileges, this started in August. In August, the state on August 18th, they filed a motion to rescind privileges. I signed an order rescinding his privileges on August 24th. The defense filed a motion to partially reinstate his jail privileges. They filed that on September 8th. I granted the defense motion, allowing him phone contact and visitation contact with Deontay. Advised him he may not discuss the case with witnesses. Signed the order partially reinstating phone and visit privileges on September 28th. Bail motion was filed on October 1st, and the state filed a second motion seeking to rescind his communication privileges on October 5th, just a short period after. I signed that on October 8th, and here we are today. How do the parties foresee proceeding on the latest motion to rescind his jail privileges? Counselors?
Well, I filed it outlines each and every one of the violations that I had logged. Actually, the day before the hearing, where you reinstated up until our last hearing.
You're talking about the offer of proof filed on October 5?
That's right.
All right, very good. Attorney Schwan?
Your Honor, the court is right about the procedural posture of the case. The court granted the state's request. I think there was actually a hearing October 6th where the court granted it, and then the order was signed a few days later. Mr. Robinson has been in compliance with the order since. I don't think that the state's offer of proof does involve anything regarding appropriate contact with Deontay Robinson, although I'm sure I'll be corrected if I'm wrong. I don't recall that there was anything involving Deontay. I am asking the court to consider still making one person be an exception to the order so that Mr. Robinson's sole contact with the outside world is not limited to me, his counsel.
All right, well, I did that a while ago, and then I received the state's motion, and I think their offer of proof is compelling. They've indicated they've listened to hundreds, if not thousands, of Mr. Daquan Robinson's phone calls, probably nearly all, if not all of his phone calls, and that they recognize his voice. The order in which his privileges were reinstated, as I indicated, was on September 25th. And it's alleged that, if I'm reading this correctly, and it's slightly complicated with all the names and the nicknames, by September 26th and 29th, we have a violation. The allegation or the offer of proof indicates that Daquan pretends to be someone else, often his brother DeMonte, who's also in custody. His mother conferenced DeMonte on the 26th and 29th. He's in the infirmary, not in any pod in the jail, as he recently underwent surgery, making it all the more credible, believable, and probable that he was unable to make phone calls from the phone of Larry Calhoun. The offer of proof indicates that of greatest concern are the calls on September 26th and 27, the day after his privileges are reinstated, with Keisha Robinson on a three-way call with Keisha, DeMonte, and Dewane. Daquan relates that he had been served with paternity papers. He had been served with paternity papers and has to go to court. State offer of proof indicates or alleges that the conversation takes place in the third person, with Daquan telling mom that he ran into Tui or Chuan in the hallway.
It's to judge and state wants.
State believes that Daquan was asking about information of Keisha on September 30th. The phrase "old girl," a common phrase when discussing someone whose name you don't want to use, is used in the phone call. On the 27th, it's alleged Daquan asked his mother to obtain DeMonte's home wife passwords because he might need it. And then the offer of proof is outlined beginning on the bottom of pages 2 through 6. I find the offer of proof compelling, quite frankly. And I am impressed with the level of time and effort that's gone into putting this together, and the fact that the state has, in fact, listened to all the phone calls that they've listened to and are able to identify the voices of various members of this family. I think that, combined with the other information in the offer of proof, makes it an extremely strong offer of proof. Mr. Robinson, if I had a way for you to have contact with the outside world, I would. I tried once, and I am convinced that by the next day you were in violation of the court's orders. So the motion to rescind all of your privileges stands. Sorry, Attorney Schwantes, that he is the only person that he can have contact with is you. He had a second chance, and to say he blew it's an understatement. He blew it within a day. So the state's, as I indicated, the order stands that I have already signed on October 8th. Now we come to the defense motion to modify bail under 971.10 sub 4. It's very well thought out. It's very detailed. It makes some very, very good, strong arguments. And Attorney Schwantes, on behalf of Mr. Robinson, is asking that his bail of $500,000 cash be reduced to a personal recognizance bond. And Attorney Schwantes outlines and puts in point number 6, this issue is simple. As of July 20th, jury trials resumed in Milwaukee. It makes sense that any court in Milwaukee, between the time jury trials were suspended by the Supreme Court order in March of 2020 and when Milwaukee County trials resumed, would find good cause. And Attorney Schwantes goes on to argue that this is no longer the case, that Mr. Robinson's demand for a speedy trial was filed on July 6th, by operation of the Supreme Court order, a Milwaukee County order was suspended or tolled until July 20th. July 20th, trials resumed. Goes on to argue that appropriate good cause findings were not made by the court. Mr. Robinson's trial, which was set for September 14th, was unable to go on that day due to the fact that the state had 30 to 70 witnesses, jury selection being slower than usual, and that he never conceded or stipulated to a tolling of time limits. And we apparently tried to do a hearing of this on September 25th via Zoom. And Attorney Schwante said he could not understand what the court was saying about, as he could hear only about every fifth word was audible via Zoom. I remember that hearing. It was extremely challenging. I don't think anybody could hear anything. So he argues that under 971.10 sub 3 and sub 4, that Mr. Robinson should be released under a personal recognizance bond, and talks about Mr. Robinson's significant work history that is outlined all in point 25 of his motion. He talks about the fact that Mr. Robinson has ties to Milwaukee and all the other reasons that he is a good bail risk. From the state?
I think the bulk of this motion is identical to the last one as well. No circumstances have changed in the interim of the time period. The issue, although Mr. Trump says it's simple, obviously it's not. And what I found quite interesting was I got Mr. Schwantz's bail process when it's before court today, and about 5 minutes later, I found the Supreme Court order extending the emergency orders of the state of Wisconsin used. The idea that 35 live on the law, I think is counterproductive. We're not even here. Or in any position to for the speed office, who has filed speed office. There's no secret of what other forces done to do that television anyway. One of the considerations I say, and there's no such consideration. Again, as I said, most of the saying all of this community involvements are the same position with including again at number 28, it doesn't do better with alcohol. We counter that with countless incidents of use of drugs, and even included in this case is text messages with the witness that we're always working on, the ones that are left at their house and stated in the comment. I think the smallest whether or not on this particular issue. I thought it had maybe insufficient record. I do believe the last time we had made a sufficient record of this detention to our rights. I believe if you go under 971.103, the anti-justice for by taking action that will invest into the public and will defend it in this trial. We're in a situation here, the Supreme Court recognized rights including defendants. And other than that, there are no two situations that would warrant the change.
Thank you. All right. Taking a,
Can I just for the record?
you may, please go ahead.
I wanted to things that were just said. Thank you. I have to take issue with the comment that the Supreme Court has recognized that speedy trial shall be suspended. They in fact did not do that. When the Supreme Court made a decision that circuit courts could reopen upon approval of a safety plan, a public health plan, they didn't say anything about 971.10. They didn't say anything about constitutional or statutory speedy trial rights. In fact, they said as long as the plan is approved, courts can read it without reservation. They had an opportunity at that point to actually say, this is an emergency situation. Following reasons, we are exercising our powers, the Supreme Court, to establish a procedure by which trial judges can suspend 971.10. They did not do that. And I want to just point out that this order applied to all 72 counties. So 1 judge county, 4 judge counties, 47 judge counties all had to submit a plan for the Supreme Court to let them reopen. If you are in Trempealeau County where there's 1 judge and they're operating as normal, with trial capacity in many other places in the state. But what the Supreme Court did not do, they did not say anything about 971.10. And I'm asking for a remedy under that. The other thing I want to point out that I did not have in my motion is, as the court knows, bail is supposed to be set amount to ensure someone's appearance in court. And there's other provisions as well, but I want to focus on that one. We now have a situation where when somebody is held in prison or jail while awaiting trial, they would be unlikely to appear in court because they cannot be transported from CJF, Bus Correction, Dodge Correctional Institution, MSDF, wherever they are. And they may not be transported for their hearings to appear for the trial because of the pandemic. So bail, again, is supposed to be set only in the amount to ensure someone's appearance in court. We now have this paradoxical situation where the cliche about, hey, he needs to have high bail and maybe sit in custody, that's the only way we can ensure his appearance in court, is kind of turned on its head. Because as you know, from Monday even, when the court had a trial calendar, there was a question as to whether criminal defendants confined with speedy trial demands would be able to be transported for their jury trials because of the pandemic. So I think there's this additional wrinkle where $500,000 cash bond may not ensure Mr. Robinson's appearance in court for his trial on March 15th. We've got this winter coming. Things are getting worse. They're hopefully getting better someday. And I know all this is speculation, but I don't think the court can find that Mr. Robinson's continued confinement is necessary to ensure his appearance in court when we don't even know if he's going to be able to get to court, based on how things are happening in our various pods locally, at the jail, in our confined settings, as well as in the prison system. I also want to point out that the ties that Mr. Robinson has to the community and his family, most importantly, show that he doesn't have the ability to go anywhere else in the world. He can't get anywhere else. The state has also talked about, as a final matter, the strength of their case, and I understand their points on that. It is worth saying, I think, and pointing out that Mr. Robinson has been confined for 13 months. If he came from a wealthy family, he would be out of custody. He would have been out of custody regardless of the strength or lack thereof of the state's case. He just wouldn't be here right now. He's here because he doesn't have money. He qualifies for a public defender. His family doesn't have money. So regardless of, all this is doing is keeping a person who doesn't have anything locked up. So I think that because any finding under 971.10(3) amounts to a finding that because of the pandemic, we don't have capacity to do jury trials, which to my ears sounds a heck of a lot like court congestion, which that statute says cannot be used as a basis to deny somebody a speedy trial right. The fact that the Supreme Court approved Milwaukee County for having jury trials without saying anything about 971.10 when they could have, the only thing that we can really do is follow the law. And so I'm asking the court to find that not having the capacity to do this is not good cause. And I'm asking the court to discharge him from custody. I'm asking the court to set whatever stringent conditions need to be set. He has a
He
plea.
won't follow them, Attorney Schwantes. That's part of the problem. He won't follow them, as evidenced by the phone calls a couple days after the order was modified, rescinding his privileges. He's a horrible bail risk.
Well, that's
That's the problem.
the argument. Okay, let me back up on that. You know, the evidence in the offer of proof, even the state contains no direct evidence of, you know, witness intimidation or anything like that. If it had, they'd be filing those charges, and they'd be filing.
But let's have a conversation about that. It shows that he doesn't follow court orders. Attorney Schwantes,
It shows that he's naive, he's new to the system, he's never been in this process, he's never been locked up before, he's never, certainly not for 13 months, he's never been away from his family this long. So, I mean, you can set conditions like, for example, 24-hour curfew, release to go see attorney and medical appointments. You can set exclusion zones on the GPS so that he's nowhere near, you know, certain people, you know, and I think that, you know, that would be appropriate. I also think, again, we're going to be back here in March, and I've seen your March trial calendar, Judge, and I know a lot of things can change, but, you know, there's more than a dozen trials set on that day, I think.
yeah, you are our priority, though.
No, I understand, and I appreciate that, and Mr. Robinson, I think that I just think that under all the circumstances, him being locked up is going to guarantee that he'll be here for court the way the pandemic's going. With that, I have nothing further. Thank you for allowing me to make a record.
All right, so Attorney Schwantes, you make two really, I think, interesting and novel arguments. One is that the partial reopening in Milwaukee County sounds a lot like port congestion to you. And the other is, if bail is set to assure someone's appearance in court, hey, having them locked up and maybe not being able to appear, yeah, it's got the same risk. Well, I think they're two really different things. I think it's a little bit broader when you say the purpose of bail is to assure someone's appearance in court. I mean, if you think about that, it's to make sure that they're here in the system, that they're here and that they're as available as they can be, that they're going to be here, not just walking in the door. Him being out in the community, quite frankly, exposed to the pandemic, puts him at the same risk as if he were in custody. Clearly, that's a novel interpretation. It's interesting, it's creative, but the whole concept is he going to return? Is he going to return to court? And my God, your argument would be so much better if he had conformed his conduct during the period of time that his communication order was, you know, partially rescinded. I have absolutely zero belief that Mr. Robinson is going to follow any rules, that he's going to do anything that he's supposed to do. He's not naive, Attorney Schwantes. What he did in making those phone calls, using somebody else's PIN, using words that are used in the vernacular to hide someone's identity, being careful as to how he identified himself on the phone calls, that's not someone who's naive. That's someone who's circumventing court orders for his own benefit. I don't believe, quite frankly, that Mr. Robinson would follow any court order if he got to walk out the door. So is he a good bail risk? Absolutely not. Now the question then becomes, so does he need to be released regardless because the court is unable to provide him with a speedy jury trial? And contrary to 971.0. And I don't think so, because 971-1038, court may grant a continuance upon its own motion or the motion of any party if the ends of justice are served by taking action that outweigh the best interest of the public and the defendant in a speedy trial. A continuance shall not be granted unless the court sets forth in the record its reasons for the finding that the ends of justice served by granting of the continuance outweigh the best interests of the public. Factors to be discussed: whether the failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. The only way we can get this trial in, and part of that is Attorney Schwantes, and you and Mr. Robinson can try this case any way you want to, was, if I'm remembering correctly, a refusal to stipulate to anything that might have moved the trial along that wasn't necessarily a component so important of what would have been your trial strategy.
Judge,
No.
I have to jump in. There was never any discussions about stipulations. I think Attorney Lewis mentioned at one point when the issue of the amended witness list was filed that she would try to whittle it down and that maybe there could be a discussion about stipulations, but we never had that discussion. So it's not on us. That witness list was not on the defense. Failure to stipulate because we didn't have that discussion. Just in fairness to Mr. Robinson, that discussion never happened.
All right, then I will take that. I will disregard that. But what we've got is a matter with between 30 and 70 witnesses that we need 2 weeks for. We have 2 weeks in March. I don't have time before that. And as everybody knows, these are the strangest of times. This court has not tried a jury trial since March. And not that we have not attempted, as everybody in here knows, we have been attempting to try cases on the weeks that we have been assigned. Is the case so unusual and complex due to the number of defendants or the nature of prosecution that it's unreasonable to expect adequate preparation? I don't think that was really relevant. I think everybody here would have been able to go ahead. The interests of the victim, and no continuance may be granted because of general congestion of the court's calendar. It's not general congestion of the court's calendar. There's a pandemic that everybody has recognized, a global pandemic. Everybody from parts of the White House to the whole global community, and it's brought things pretty much to a halt in many ways, but to the best of our ability, we are proceeding with jury trials. One of my colleagues is doing a jury trial this week. I had 2 jury panels brought to my courtroom, one on Monday morning and the case resolved. Another jury was selected Monday afternoon for a separate case, and somebody did not meet the criteria to enter into the building. These are strange and different times, but I do not believe that it is in the interest of the public to release Mr. Robinson on a personal recognizance bond. We have a trial date set in March, and contrary to your best efforts, Attorney Schwantes, Mr. Robinson is a horrible bail risk. And based on the conversations that I've heard about with his family members, I would think it would be more likely than not that they would assist in ensuring that he does not return to court. So the request to modify bail is denied. We've got our trial date. You are our #1 trial for that week. We're setting other matters in the event that something strange happens, as tends to. Things are very unforeseen. Things are very fluid. You are our #1 trial that week. We had, in the middle of summer, thinking things might get better. We started on our own, handing out other trial dates, hoping that court administration would allow us to open other court dates. That hasn't happened. I'd also note this court trial is obviously going to take more than a week. Monday afternoon, I asked for permission to bring in more than 30 potential jurors for the trial that we had, and that was not allowed. The county did not have health provisions to have more than 30 potential jurors. In Mr. Robinson's case, it's pretty clear to me, we're going to be having to select at least, we're going to have to bring up at least 2 panels unless things change. I'm hopeful for a vaccine, but I don't know that it's going to be provided in a widespread manner by that point. All right, we've got our next court dates.
Next court, January 14th at 9 o'clock.